you have a client who's pled guilty to healthcare fraud charges, it's important that you ensure that the guideline calculation for that healthcare fraud is done appropriately. The guidelines in fraud cases are driven by something called the loss amount. The loss amount in the healthcare fraud context is typically the amount billed by the entity to Medicare. However, there are some arguments available to you if you can show that your client didn't intend to receive the amount that was actually billed by Medicare, but actually intended to receive the received amount, which is actually a lot lower. So for instance, if a cardiologist was doing 1,000 procedures that year and billed it out at $1,000, they might calculate the loss amount as every procedure $1,000 a pop. But in reality, what should be done is sampling and extrapolation of the procedures that were done to determine the loss amount. You should have somebody review a statistically significant sample of records of that provider for the time period of the alleged fraudulent activity. If you lack the expert support to get that type of work done, it's important for you to contact a healthcare law firm such as Chapman Law Group today.